Ihmiset oli juuttunut sinne hissiin taas.
Eikä. So we will wait for a couple of minutes more. There has been some problems with the elevators here in the seminar hall building. Yeah. So, perhaps we can start now. I guess the people from the elevators have found their way here. Welcome to this seminar on environment and human rights, organized by the KIOS Foundation and the Siemenpuu Foundation. I am Hanna Matinpuro, and the Executive Director of the Siemenpuu Foundation. I will be moderating today this seminar. Few first words on practicalities first. As you know, this is streamed as well, the seminar. It will be available, it will be recorded also and available in the KIOS Foundation's YouTube channel for 2 weeks at least after this today. And a Vimeo account of the Siemenpuu also. We will try to accommodate also the questions raised in those who are following the live stream. You can make the questions there in the chat functionality, but we try to accommodate those as well as those questions from the seminar hall here. And here in the seminar hall, please use the mic when making the questions. I guess it's easiest if you come here in the front to use the mic to make the questions. After all this information on the possibilities to make questions, I have to unfortunately inform you also that there will be quite limited time for the questions from the audience, especially in this opening session and the first 2 panel sessions. We will hopefully have some questions, time for some, but we will have more time in the end, in the last discussion sessions. And the last session will also combine all the elements of today, so that will be the time also to continue the discussion together. And then one last thing about the practicalities, we will have about 10 to 15 minutes break after this opening and the 2 panel sessions. And then we will continue. But back to the team. With this seminar, KIOS and Siemenpuu want to highlight the link between human rights and environment. And we need a safe, clean, healthy and sustainable environment in order to respect, protect and fulfill human rights. And we need also to respect, protect and fulfill human rights in order to ensure a safe, clean, healthy and sustainable environment. This understanding has been the basis for both foundations, KIOS and Siemenpuu, since beginning of our operations. We 2 foundations, we share a common history, as we both were founded about 20 years ago by Finnish NGOs in cooperation with the Finnish Ministry for Foreign Affairs. And we both support the work of civil society movements in the Global South. KIOS working more from the human rights angle and the Siemenpuu from the environmental angle, but combining a lot the same issues. And the local actors, civil society movements and human rights defenders and environmental defenders defending rights of the local communities and indigenous people are in the are the core actors who we support in the Global South. And today's seminar, we will learn more together with our guests from Kenya, Nepal, Samiland and Finland. And we hope to learn together what to do better and how to support environmental defenders, especially in the Global South, but also here in the Global North. But without further ado, I would like to welcome Johanna Sumuvuori, the State Secretary to the Ministry for Foreign Affairs of Finland, to give the opening remarks.
Thank you very much. Thank you for KIOS and Siemenpuu Foundation for inviting me to address this very timely seminar. For a start, I'd like to make a statement that we have a human rights-based foreign and security policy in Finland. It's firmly stated in our government program, and it's also firmly stated in our foreign and security policy report, and that's something that we cherish a lot. And at the beginning of this year, we also became a member of the UN Human Rights Council. So human rights are very at the core of our priorities. And also to mention, referring to your headline here, human rights and the environment, environmental defenders on the front line, we have also been talking a lot about how to defend, how to protect better human rights defenders, and that has been also a great priority of my minister, Minister Haavisto. So I think that I'm in the right place to discuss with you today. There's also environmental issues and climate change is something that is more and more at the front of the human rights agenda. Climate change, environmental degradation and the loss of biodiversity are exposing humankind to unprecedented challenges regarding safeguarding our living conditions and human rights. The interdependence between human rights and the environment has become evident, and environmental urgency and climate crisis have human rights impacts. Those who work to combat climate change and to protect the environment contribute to the protection of the human rights. Finland actively engages on the interlinkage between human rights and the environment, biodiversity and climate change in international and regional fora, and the UN and the Council of Europe, amongst others. In recent years, the Human Rights Council has put emphasis on the human rights impacts of climate change and the environment. Last autumn, the Council took 2 landmark decisions on these topics. It adopted resolution on the right to a clean, healthy and sustainable environment, and also it created an expert mandate on climate change and human rights. The landmark resolution recognized for the first time that having a clean, healthy and sustainable environment is a human right and called on states to work together and with other partners to implement this right. The resolution is about protecting people and the environment, and it acknowledges the human rights, people's well-being and health are interlinked with a healthy environment, and that environmental crises potentially violate our human rights. It also underlines that people in vulnerable situations are more acutely impacted by climate change and environmental degradation. The resolution also invited the United Nations General Assembly to consider the matter at a broader organizational level later this year. The core group on human rights and the environment, including Costa Rica, Maldives, Morocco, Slovenia and Switzerland, issued a joint statement in April announcing that they will launch this process in the coming months. Finland firmly supports that the UN General Assembly recognizes this right. There is already a widespread legal recognition of the right to a healthy environment at international, regional and national levels. As more 150 countries legally recognize the right to a healthy environment, a recognition by the Human Rights Council as well as a possible recognition by the UN General Assembly can assist in making substantial changes in many countries. While not binding, the UN resolutions have been vital in encouraging and guiding states to adopt and implement policies and legal frameworks that will protect people and the environment. This June session of the Human Rights Council, we look forward to getting the first report by the Special Rapporteur on the promotion and protection of human rights in the context of climate change. We support Mr. Ian Fry's work in this, and that he also would collaborate closely with other special rapporteurs, for example, in right to environment, human rights defenders, right to health, and so forth, of the Council to ensure maximum impact of his mandate. Finland is committed to continue working on these issues as a member of the Human Rights Council, and we put emphasis also on the interlinkage between the environment and the full realization of human rights, especially of those in the most vulnerable positions or situations. Nationally, we are currently working on a new environmental protection law, and the Parliament just voted in favor of a new Climate Change Act. And the Finnish Sami people, as well as a wide range of civil society representatives, are very much involved in the reform process. Our constitution already includes a provision on responsibility for the environment, and the government report on human rights policy raises sustainable development as one of its main topics. Environmental and land defenders are at the forefront of climate and environmental crisis. Yet they face increasing danger for the persistent efforts to protect the environment and promote sustainable development. According to reports, over 200 environmental human rights defenders were killed in 2020. These killings mainly took place in the context of ongoing conflict, violence and instability. Over 1/3 of deadly attacks were linked to logging, mining, small agribusiness and hydropower dams and other infrastructure. Other forms of aggression against defenders included death threats, judicial harassment, intimidation, beatings and violence. Environmental human rights defenders in vulnerable situations often face heightened risk of violence or harassment, such as women, indigenous peoples, LGBTI plus persons and persons with disabilities. Indigenous environmental human rights defenders who often live in remote areas are disproportionately subject to killings and violence, and indigenous peoples account for only 5% of the world's population. They help protect 80% of the world's biodiversity. Indigenous people's traditional knowledge is vital to the resilience of our ecosystems. Women environmental human rights defenders often face additional challenges in their work, being subjected to certain forms of violence and other violations, including sexual and gender-based violence, both online and offline. It is important that the gender perspective is systematically integrated to the support and safety measures for environmental human rights defenders. Ensuring that environmental human rights defenders can work without fear of harassment, persecution or losing their lives is a priority for Finland. Human rights defenders are important partners for us, and they have important information on the human rights situations on the ground. So we actively engage with human rights defenders in the Finnish government. The Ministry for Foreign Affairs of Finland has actually guidelines on supporting human rights defenders, and they are based on similar guidelines by the European Union. These guidelines have helped our embassies to increase dialogue with and support to human rights defenders, and they're currently being actually updated, taking into account an independent report concerning Finland's support for human rights defenders. So Finland provides financial support to civil society organizations for their work to support human rights defenders. And for example, we support Frontline Defenders, which provides a fast and flexible and effective 24-hour emergency service that responds to the protection needs of human rights defenders at immediate risk. We collaborate also closely with our NGO partners on raising awareness, and this event today is also being one example of that. In April 2021, we organized a panel discussion with human rights defenders and ISHR on the theme Diverse World, Defending Human Rights Together. And this marks an event on women human rights defenders in conflict and post-conflict situations. It is important to ensure a strong global message for the protection of environmental human rights defenders and the promotion of their rights. Their role as agents of change to mitigate and adapt to climate change and to protect the environment and improve conditions for food security is vital for sustainable development. And with these opening remarks, I'd really like to thank for convening this meeting, and also to thank for all the good cooperation we have had so far from the Foreign Ministry with the NGOs and human rights defenders, and also I can guarantee that it will continue to be at the core of our policies in the government. Thank you.
Thank you, Johanna. And I can really much agree what Johanna said about the importance of the cooperation here in Finland and the good cooperation that we have the NGOs and the foundations with the ministry. And thanks to that. And I think it's also very important for us when we have this good opportunity for cooperation here in Finland to use this for full potential and to help the other countries also to move forward to the same direction together. And I hope that this discussion today will help us also to find more ways how to work on to protect also the environmental defenders. But next I would like to ask Dorothée Cambou to give a keynote speech, a global human right to a healthy and sustainable environment and equal consecration to ecological and just transformations. Dorothée Cambou is an assistant professor of sustainability science at the Faculty of Law at the University of Helsinki. Her research focus lies in international law and human rights, and her expertise is especially in the field of indigenous people's rights, land and resource governance. She is active in several Nordic and Arctic research networks, and she has been also an expert member of the research project on the status of human rights performance of Finnish companies, commissioned by the Finnish Prime Minister's Office. And she is also a member in Siemenpuu Foundation voluntary working group, so she has very good overview of the issues. Thank you, and the floor is yours.
Thank you, Hanna. Good morning, everyone. First of all, I have to say it's a pleasure to be here, especially to speak about such an important topic as the human right to safe, clean, healthy, and sustainable environment. As I begin this presentation, I want to emphasize again that last year, on October 8th, the Human Rights Council recognized for the first time that having a clean, healthy, and sustainable environment is a human right. The 2021 resolution was supported by 1,300 NGO groups, including indigenous people, as well as 15 UN agencies and business groups, and was adopted by 43 states. The adoption of the UN resolution represents a real achievement in international law because it reflects a growing universal recognition of the links between human rights and the protection of the environment. It is now indeed increasingly established that the protection of the environment is a condition sine qua non for protecting human rights. Yet, despite this legal development, the fact remains that the degradation of the environment has continued to deteriorate at a phenomenal speed with the arrival of the Anthropocene. To address this issue, it is therefore asserted that the international community should take action and recognize an international right to a healthy environment. Although this right is increasingly recognized at the regional and national level, the puzzling fact remains indeed that the right to a healthy environment is still not formally recognized at the international level. There is simply no international legal binding instrument that recognizes this right. Consequently, the Human Rights Council concluded in its resolution adopted last year by inviting the UN General Assembly to consider the recognition of such a right at the international level. Like many others, I do believe that recognizing the right to a healthy environment at the international level must be promoted. In this regard, the purpose of my presentation today is to explain what is the added value of such a right. First, and in line with the content of this seminar, I will underline the added value of such a right as a catalyst for change to address the deficit of the global environmental governance. From this standpoint, my goal is to underline the instrumental value of the right for environmental defenders in their battle to protect the environment. Second, I also want to underline the importance of recognizing the human right to a healthy environment to achieve ecological and just transformation. In this regard, my attention is particularly focused on the importance of recognizing such a right to tackle the legacy of colonialism, discrimination, and inequality, which still affect millions of people around the world, but most importantly, indigenous people. In this regard, my general argument is that recognizing an international human right to a healthy environment is a means to bridge ecological protection with social, environmental, and climate justice. So, to understand the added value of the right to a healthy environment, it is first important to look back at the progress we have achieved so far, but also shortcomings. For more than 40 years, the international community proclaimed its goal of defending and improving the human rights environment for present and future generations. During these 4 decades, there have been explosion of environmental regulation all around the world at the national and international level. In addition, the number and scope of international and domestic law, judicial decisions, and academic studies regarding the link between human rights and the environment have also grown rapidly. As evidenced by this world map, over 100 national constitutions already recognize the right to a healthy environment. Yet, as this map also demonstrates, not all states have recognized the right to a healthy environment, and more problematically, some of the most powerful economies and emitters of CO2, namely the USA and China, still oppose the recognition of such a right. In this regard, the international recognition of the right to a healthy environment is important because it could increase efforts for the formal recognition of the right by those states that do not yet explicitly recognize the right in their domestic legal order. In addition, such a recognition would also help to clarify and strengthen the recognition of the right at the national and regional level. As we see, despite an overwhelming recognition of the right to a healthy environment, many states around the world still fail to protect the environment in a sufficient manner. And there is often, in fact, shortcoming in the legal framework or its implementation. It is therefore argued that providing recognition for a right to a healthy environment would help to strengthen the content and implementation of constitutional provision, legislation, and policy at the national and regional level. It will also help to improve the governance framework for environmental protection at the global level. This said, let me also explain that the recognition of the right to a healthy environment is not panacea for solving the environmental crisis. However, it is an instrument of change that can facilitate and improve the work of environmental defenders. First, the right to a healthy environment can provide additional safety for environmental defenders. Providing safety for environmental defenders in the light of the opening remark cannot be overstated, especially when we know that the majority of human rights activists killed last year were defenders working for improving the protection of land and nature. With the recognition of the right to a healthy environment, there is an opportunity to create mechanisms that will be better to protect environmental defenders in their work, so they can challenge state and corporate actors without risking their security or endangering their life. Beyond the question of safety, the recognition of a human right to a healthy environment provides an additional tool to challenge states and corporate actors for failing to take action to protect the environment. Recognizing such a right often implies guaranteeing or improving procedural rights, such as a right to receive information, to participate in decision-making about environmental matters, and to obtain access to the justice system. In addition, the right has substantive components, which are linked with the obligation of state and private actors to protect the environment. In this regard, the human right to a healthy environment does not only protect environmental defenders, but also provide a tool to empower them procedurally and substantively to challenge state and non-state actors to protect, respect, and fulfill these rights. In fact, court battles invoking the right to a healthy environment are already frequent and have steered the development of an increasing body of decision which rely on human rights to protect the environment, both at the regional and national levels. At the regional level, the indigenous people of Laka have successfully petitioned the Inter-American Court in 2020 for protecting the land against deforestation on the basis of the failure of the state of Argentina and arguing that the state failed to protect their right to a healthy environment. They were among the first also to attempt to hold the government accountable for the impact of climate change. Although indigenous people were initially unsuccessful to hold government accountable for the harmful effect of global warming, linking environment and human rights protection has recently become a powerful instrument in the fight against climate change. The Urgenda judgment of 2019, as shown in this picture, it was the first case in the world to establish that there was a legal duty on the government to prevent climate change on the basis of human rights. More recently, in the Shell case, linking human rights to combat climate change was again a successful strategy to hold companies this time responsible for their fair share of CO2 emission. In this case, a Dutch court marked another milestone in the history of climate litigation by requesting Royal Dutch Shell to reduce its CO2 emission on the ground that the company is violating human rights by contributing to global warming. The ruling is particularly significant because until now it has been proven very difficult to hold the company accountable and hold them accountable for their responsibility towards climate change. So therefore, using human rights law is becoming a powerful instrument in litigating against state and corporate actors for their failure to take adequate action to protect the environment. Despite this success, what must be underlined is that there are many obstacles that often prevent environmental defenders to succeed in court. National and regional courts are, as well as human rights treaty bodies, are not well equipped to address and monitor issues raised by the right to a healthy environment. In this regard, it is argued that the recognition of a right to a healthy environment provides a means to overcome classical hurdles in human rights-based environment litigation, including the standard of proof, causality, and attribution of responsibility. In summary, the legal recognition of the right to a healthy environment will further strengthen procedural and substantive obligation towards the protection of the environment. It will help to improve support for individual group, NGOs, indigenous people, and judges to support and strengthen the content, implementation, and enforcement of those obligations to protect the environment. At the same time, it is not sufficient to improve procedural and substantive obligations regarding the protection of the environment. In addition, we must ensure that environmental protection does not discriminate but benefit people in the most vulnerable situation. This is particularly the case in relation to the impact of mitigation measures taken to address climate change, which negatively impact human rights in some cases. For example, there is an increasing number of complaints against wind energy projects due to their negative impact on human rights, more specifically on the right of indigenous people. Last winter, the Supreme Court of Norway decided that the Fosen wind energy project, which, by the way, is the largest wind energy project in Europe, was in violation of the right of the Sami people. During the case, the companies and the state of Norway had argued that the green shift provided a justification for the building of this wind project. On the other hand, Sami representatives and activists have opposed the project due to its impact on reindeer herding and denunciated the project for being a case of green colonialism. In its decision, the court concluded that the right to a healthy environment was not in collision with the human rights of the Sami people to culture, and that the government should have chosen less intrusive development method in order to secure the cultural right of the Sami people. But there are other examples which demonstrate the necessity to integrate more firmly the protection of the environment with human rights. In relation to conservation issue, we have seen how the discourse on conservation can harm local community when it neglects to consider the right to access to land, to food and water. In this respect, the African Court of Human Rights, in the Ogi case in 2017, recognized that the protection of the forest could not justify the eviction of the Ogi indigenous people from their ancestral land in Kenya. More recently, in Finland, the Supreme Court ruled in 2 cases that members of the Sami indigenous people were not legally responsible for having violated fishing regulation. In the case, the government had set limits on the right to fish to protect the sustainability and biodiversity of fish species. But these rules were found by the court to violate the right of the Sami as protected by the Finnish constitution and human rights law, in particular the ICCPR. Against this background, I hope my argument becomes clear. Protecting the environment without ensuring human rights protection, including those of indigenous people, leads to further discriminate individual and group, as well as reinforce pattern of colonial domination. Adopting a human right to a healthy environment is a way to address this issue. By further integrating human rights with environmental protection and by putting human rights at the center of the green transition, we can then achieve ecological and just transformation. By way of concluding this short presentation, let me stress once more that the recognition of the human right to a healthy environment at the international level has an added value. Although the recognition of such a right is by no means a solution to the global crisis, its instrumentality to solve this crisis cannot be neglected and should be promoted. From a legal perspective, recognizing the protection of the environment as a new international human right would provide the foundation for the development of a stronger body of law to protect the environment. If recognized by the General Assembly, this right may well be a catalyst for changes because it could improve environmental law and their implementation at the national, regional, and global level. More radically, and depending upon the articulation of the right to a healthy environment has the potential to strengthen the governance of the environment for the benefit of all, including indigenous people. In other words, and here I will conclude, consecrating the right to a healthy environment could therefore lead to ecological and just transformation. I thank you all for listening to me, and I also thank you for all what you are doing to protect the planet and human rights in your work, because I'm well aware that in this room we have a number of strong activists. Thank you.
For if there's any questions for clarification or something, but if not, I guess we will continue the discussion and go deeper to the issues in next panel discussions. So thank you, Dorothée. We will continue, and Dorothée will be joining the second panel discussion later on. But first we will have a Heta-Elena Heiskanen. Please welcome. Heta will be moderating the first panel discussion. And I could ask already Matti and Phyllis also to come here to take the floor and microphones. Heta is the senior specialist in the Finnish Ministry of the Environment, and there her work is connected with the Finnish Climate Change Panel and climate policy. As a researcher, she has specialized in international human rights, law, and environmental matters as well. But possibly you could explain more about your background, and I give the floor to you.
Thank you so much. Dear all, we are here because we have some serious issues with the planet, right? And I think I just have really bad news. The IPCC is very clear that half of the population of the whole planet is living in the vulnerable areas where their human rights are in great risk because of climate crisis. Half of the population of the whole planet. The United Nations is also very clear that climate crisis is not just an environmental problem. it is also a human rights problem. It's actually one of the most severe and most troublesome problem we have. And this have not been only a one statement from the United Nations, but they have been repeating this for many years. Climate crisis is a crisis of disabled people. It is a human rights crisis of children. It is a human rights crisis of indigenous people. It is a human rights crisis of women, elderly people, all the vulnerable groups. Every one of us is experiencing climate crisis. And today I have privilege to have two people who have not been just crying and became anxious about this news, but they have chosen to act for human rights and for the environment. So I have a great privilege to have a friend of mine, Phyllis Omido, from far away from Kenya, here today. She's a very wise and brave woman from Mombasa area. She is an activist with a really big heart. She's been defending the rights of local people in Kenya against lead poisoning and different kind of environmental degradation. And she's been not just going out to the street, but actually litigate for the rights of the people. And she's been listed also as one of the most influential people of the world. So we are really privileged to have you here, Phyllis.
Thank you. Thank you so much.
And then we have Matti Kattainen from Finnish Association for Nature Conservation. And you have a background as an environmental lawyer. So you are using most of the legal measures of Finland, I guess. And you are specialized in this, practically realizing human rights in practice in environmental protection. So I'm very pleased to have you here today.
Nice to be here.
Yes. So I started with the bad news, and I think I will share a little bit of good news as well from Finland, because it's very topical that last week our parliament approved a new climate act. It's a good news, and we have not been celebrating that as much as we did, for instance, ice hockey championship. But I think we should also celebrate, at least today, a little bit about our climate act also, because I'm really proud that we have established and accepted, for instance, a new Sami Council for Climate Change in the Climate Act. It's going to be binding. I think this is something that is establishing a strong standing, that indigenous people will have a more strong standing in the climate policy in future in Finland. Also, we did human rights assessment about the Climate Act. So we tried to be really transparent and show that, well, the reform will strengthen these rights of participation, for instance. And we added there, for instance, mentioning of just transition. But let's go now to your work. So tell briefly, Phyllis, about your work on human rights and how you use the right to a healthy environment in action. And has it been a useful tool for your activism? What do you think?
So when we started our work back home in Kenya in 2009, the country had not yet recognized the right to a clean and healthy environment. And it was very hard because we were left with only trying to find a political solution for a community of 3,000 people who had been exposed to heavy metal poisoning and lead poisoning. And therefore, we had no avenue, really, to access justice and effective remedies for the Owino community. However, in 2010, Kenya promulgated a new constitution, and within that constitution, Article 42 recognized the right to a clean and healthy environment. And with this recognition, the Kenyan jurisdiction implemented the Land and Environment Court in Kenya, where land and environment defenders could bring cases that touched on their communities. And therefore, in 2016, we brought a case to court, class action litigation, challenging the responsibility of 6 state agencies and 2 corporations towards the right to a clean and healthy environment. We were also asking the court for some declarations in terms of access to information and public participation rights of the community, because we believe that this had been violated during the licensing process of the smelter. And the case ran from 2016 up to 2020, where the Land and Environment Court granted the Unohuru community remedies running up to $12 million. And they granted Center for Justice the responsibility of cleaning up the environment and allocated $7 million towards that. It was quite a huge victory for the community. Thank you so much. It was quite a huge victory for the community. And quite unfortunately, the Chief Justice decided to stay the execution of the decree, and 2 state agencies went to the Court of Appeal to appeal the case. So we are now at the appeal stage. We'll be back in court on July 4th. And we are still hoping for the best from the Kenyan jurisdiction. Just to mention, however, that the recognition of the right to a clean and healthy environment in our case, for example, gave us a very good tool to use to protect the community's rights. However, there needs to be goodwill from the states. Because at the same time that the Unohuru community was battling with lead poisoning, I know that also in Flint, Michigan, in the US, there's a community that had been exposed to lead poisoning. Whereas their levels were very low, around 35, our levels were very high, up to 420 micrograms per deciliter of lead in blood. The US Attorney General, however, ensured that they had sat with the community and the community legal team, and the community was compensated, despite the fact that the US does not recognize the right to a clean and healthy environment. While Kenya, on the other hand, recognizes the right to a clean and healthy environment, and yet it is the state itself that is fighting against the people of Unohuru's right to access justice through the legal means. So the goodwill of states, of member states, has to be there for us to actually achieve this for our people.
Yeah. Thank you for sharing this powerful story.
Thank you.
Matti, how about you? What is the meaning of human rights and right to a healthy environment in your work?
Yeah, we do use those, not maybe on the daily basis, but weekly basis on our appeals, that they are still on the background. I was think about that we only had like those environmental rights in 1995, so it's not too long ago in Finland too. So we have still cases like in land use and building rights act that we don't have access to justice, so it really helps in those cases that we have like this constitutional rights, so we can maybe have access to justice in that way. So we do use those, but it's not in the forefront of our work, but they are still significant part of our work here too.
Right. Yeah. It's really good to hear that it's in use both in Kenya and in Finland. Well, for many years I used to be a researcher, and then I was attending seminars like this before COVID, and people were asking me quite many times, like, are you a researcher on human rights or are you a researcher on environmental law? And this was repeated year after year, and they were kind of waiting that I kindly say that, well, I'm a human rights researcher or I am a researcher on environmental rights. And I always repeat them, I'm both, that these issues are interlinkage. They have interlinkage. And this was my experience for many years, and I think inherently the reason was that the human rights approach to environment was not mainstreamed yet. But I've seen many promising signs that maybe nowadays when someone starts a researcher path, she or he will not find these questions every time. But how do you find the collaboration between the environmental movement and human rights movements in your experience? Are they cooperating with each other? Are they doing parallel work? Or how is it? Is there dialogue? Maybe if Matti starts first and then Phyllis.
I find it, at least on, for example, in law reforms that we have ongoing in Finland too, that we usually find ourselves, like with Sami people and our organization, the same side. So the goals are really similar. So we can have benefits in each other on how we can push legislation in Finland. That's very good, and we have like this unofficial co-work all the time. So I think in that sense, it's like a very good that we have. You can feel it. It's in a daily basis. We are in the same size. You could say that.
So you're left alone with these issues with environmental NGOs. It's great. And Phyllis, how do you find in your work?
I think in Kenya it has taken some time for the human rights community to accept environmental rights. For many years, when you spoke about the environment in Africa, people would think about the wildlife, the elephants, the trees, but they will not think about access to information and public participation and access to effective remedies. So it has been a big challenge being accepted into the human rights world. The work that we do is neither accepted by the conservationists or the human rights people. So we are right in between. And it has been a very big challenge, even with the donor community, to speak to them about linkages between human rights and the environment. But I believe that slowly everyone is seeing, and with the recognition now of the UN Human Rights Council of the right to a clean and healthy environment, I believe that many human rights organizations will now start looking at it from our lens and accepting that violating the right to a clean and healthy environment inherently violates other rights, like the right to health, the right to life, the socioeconomic rights, and other rights. So this has been my experience in Kenya when it comes to these linkages.
Yeah. Mm-hmm. So you both see kind of the trend that it's going towards the point where human rights organizations are standing with the environmental organizations together and finding the same points. Yeah, it's very promising. I think it's better to have a wider community to back up with these things. Good to hear. So let's continue with the cooperation questions. One of the key messages that the IPCC, for instance, had was that we need everyone on board to solve climate crisis. So it can't be just left for the politicians or left for the researcher or left for the NGOs, but we need everyone. Industries, cities, legislators, artists, NGOs, indigenous people, we need like everyone. And I think in Finland, for instance, in this climate policy context, we've been trying to make wide public consultations, and in one of the consultations in recent years, we had even over 18,000 people attending, and in Finnish scales, it's a lot. So I think that also the societal actors are really willing to cooperate and be involved. And also we've been launching a new roundtable on climate change that is led by the Prime Minister, and there are representatives from different stakeholders, also from the youth and the indigenous communities, to have dialogue how to make this just transition in the right way. But how do you find in your own countries, how is the collaboration between different actors like civil society, state, businesses, and so on? Maybe Phyllis, you could start.
My experience is that it has been very challenging. I think the civil society has absorbed this very fast and very positively, but the corporate and state actors are still quite resistant in recognizing the times that we are in and the fact that for sustainable development to happen, we need to recognize the rights to a clean and healthy environment. And therefore, a lot of civil society actors, including ourselves, have been mobilizing and trying to create consensus, especially with state and corporates, because we cannot protect the environment and our people without all of us being on board and agreeing that this has to be done. I know that when it comes to corporates, it means touching on their profits. When it comes to government, it means they look at it from an economic point of view. And from this point, they are quite resistant. However, I believe that the NGOs have got it, and they are working towards the change. And I believe that in future, we are going to see change.
Yeah.
Yeah.
Yeah. So you're hopeful.
I'm very hopeful.
Yeah. I would like to add a little question to you, because I know you've been in a risk of having personal risks and having these threats and so on. So how do you find who have been giving you protection on the times when you've been seeing harassment or risk of kidnapping of children or these kind of things? Who are your partners in those kind of risky situations?
I think I was very, very privileged to have the support of various actors in society. The UN especially. I remember the time when not only myself but the people that I work with came under a big threat. The UN Office of the High Commissioner for Human Rights released a statement requiring Kenya to protect us. They did the same thing when one of my colleagues' child was kidnapped when we were putting the case in court to stop him from testifying. And also most recently, after we won the case, some goons were sent into the Winuhuru community to burn down the community. And several houses were torched. We lost 11 houses in total. This was quite recent in 2020, immediately after the court ruled in our favor. And I saw a lot of support from the international NGOs especially. I know civil rights defenders came out very strongly. They helped me to relocate some of our members, the London Environment Defenders. I know that KIOS, the Finnish Foundation for Human Rights, was monitoring our work, documenting and was in touch with us throughout the process. Organizations like Frontline Defenders. We also have some of the embassies in Kenya that stood with us during this time. So there has been a lot of support for me. But unfortunately for other grassroots defenders, because together with KIOS, we convened the Center for Justice, convenes the Kenyan network of London Environment Defenders. And within this network, even now as we speak, there are defenders that are hiding. They are in hiding because they have been criminalized. I know there's a conservationist called Rabia Hawa who has been trying to protect elephant territory, 200 elephant territory that has been earmarked for an army camp. Okay. And she has been raising questions with the where do we take the 200 elephants? And unfortunately, she has been criminalized. There are cases that have been brought against her. And also Amnesty Kenya has worked with us in trying to approach the state security agencies to try and isolate these two issues so that the security agencies are not used to repress her rights. We know also there's another female defender from the south coast of Kenya who took upon an industry that had been set up in the community and is polluting. And she has been arrested, she has been arraigned in court, her children have been threatened, she gets text messages, and she's also in hiding right now. So we have seen this trend when it's women rights defenders. The repression comes down so strongly against them. We are very grateful that we convened this network. We are able to reach these people on time. We were able to protect Rabia when the CID had been sent to her house to go and break in and take her. And we were afraid that even if they pick her up, you know, Kenya, we've had a lot of extrajudicial killings. We were afraid that she might end up dead because she's also standing against a lot of profit for individuals who gain to profit from the KDF camp. And therefore, we managed to rescue her. We managed to send her to a secure place for protection. And then we organized meetings with the police to talk to them about her case. And this, in some way, de-escalated the issue and gave us some kind of leeway to arrange for legal counsel to protect her also using the courts. So that is the situation as it is now.
Sounds really like tough situation to me, and it's I'm happy that there have been so many different actors standing by you and with you. But it's a powerful message for all of us that there are many activists that would need, you know, safety network like you. And yeah, thank you for sharing. Matti, in Finland, I think it's slightly different kind of cooperation and collaboration, I hope. How would you define it?
You have some big problems. I think we have some problems, but not in the same level. But I think we have some trust, lack of trust in some industries, and like a couple of years now. Maybe, for example, mining industry is something like the civil society doesn't have really good trust on. So there's possibilities to come together, but I think there's still some. I think there has to be some legislation reforms and stuff like that we can really build up the trust again. So and also we have many state-owned companies in Finland, like in the forest industry, that are still, and the civil society doesn't have the same direction. So I think there's possibilities and things to go further, but I don't really know what's the like medicine for that. Maybe it's just a continuous cooperation. I think so.
Right. Let's continue to seek the medicine.
Yeah.
Right. Yeah. Thank you. So the basis for is that the climate action and biodiversity action is usually benefiting human rights as well. However, we have already learned and heard today from the previous speakers that climate action can also increase some human rights problems. So there's a risk of increasing, for instance, increase of electrification requires, for example, a lot of different kind of minerals from different parts of the world. This can be contrary to the local biodiversity or local human rights. And in the same time, the conservation activities can also have a negative implications on human rights if people will be forced to relocate themselves and so on. So what do you think? How to ensure that both human rights and environmental aims can be respected during this very tricky area of climate crisis and climate action? Phyllis, what do you think? Good practices?
I think the best way is not to isolate these two. You cannot isolate human rights and isolate the right to a clean and healthy environment. If we handle this together, and there is a big possibility that we can protect people on the planet. We have seen, for example, the rights of indigenous groups in Kenya, like the Ogiek. These are forest people. They know how to coexist with nature. However, the narrative when we are conserving the environment is that these people need to leave the forest for us to conserve the forest. So where does the right of the Ogiek end and the right to a clean and healthy environment begin? So the only way is to recognize that these are intertwined. We need to recognize their indigenous rights. We need to recognize their right to live, to continue living their own way of life. And history is enough proof that these people have lived they have managed to coexist very well with nature. So why are we interfering with them, you know? So I believe that is the solution that we have.
Let's take back this solution home with us and make it real, right? Really nicely summarized. Matti, what do you think? Do you agree with this?
Yeah, I agree, and maybe a couple of things, like Dorothée pointed out earlier, we have like the Sami people, things still that we should implement, that ILO agreement, that would be one thing to do in Finland to implement that. And I have hope for in EU that, for example, that corporate sustainable due diligence directives is not perfect, but it's a good start. That kind of legislation, of course, Finland is part of that, and we usually go to the EU to get the best reforms. I think so that way, but I think those we have to come together, and there's not focus on the national legislation, but for the international legislation. So that's the way to go ahead.
Right. I think we have time for one question from the audience, if anyone is brave enough to comment or pose a question, please. I can't see any hands rising. Well, in that case, I think we can discuss later during the break, and I want to really warmly thank you for this discussion. I think you brought a lot of valuable points here. And Phyllis, I hope that you can bring some rain from here back to Kenya, because it has been so dry there, and I'm really worried about that. And for both of you, both Phyllis and Matti, I hope that may the law be with you, and may the law be with the nature's side too. Thank you.
Thank you so much, Petra.
Thank you, Heta, Phyllis, and Matti. We will continue the discussion on. We started also here a little bit about environmental defenders and their place in the society, but we will have more discussion on that in the last session. But now we will have a discussion in Indigenous people's land rights about the challenges and opportunities. And I will invite Dorothée to moderate the panel discussions. We have Shankar Limpu from Nepal, Päivi Michael from Finland, from FinFund, and also Oula Antti Lappa from Sami Council together with us. I will invite you all here. So please, Dorothée, the floor is yours.
As a starter, I want to mention that Indigenous people's right to land are so intertwined with the right to a healthy environment. In fact, what we see is that we need to discuss this topic for two main reasons. The first one is because Indigenous people are protecting their land for decades. But as we see it, in fact, they are also the ones the most impacted by environmental degradation and climate change, even though they are among the people who are the lead contributing to a CO2 emission. But the second reason is also because, as I mentioned earlier, Indigenous people have been really at the front line of advocating their rights, their human rights, to protect the environment, and that is for decades. So, in fact, the example of Indigenous people, leadership in environmental protection should be followed. So here I have the chance to have very good panelists who can discuss about their experience working either alongside Indigenous people or actively engaging in the struggle of protecting the environment. So as a first brief question, I hope you could introduce your work. First, I will give maybe the word to Shankar, and if you could say a few words about how you work in your organization and support the right of indigenous people to land, and explain this for the audience, that would be great.
Thank you very much. Sewaro, greetings in my community language. I am a practicing lawyer from Nepal. I'm associated with an organization called Lahornip, and it's a human rights organizations working to protect, promote, and defend the indigenous people's rights in Nepal. And we are partnering with KIOS here, and we've been doing several activities to protect the indigenous peoples, especially the land rights, the collective rights, and human rights as well. And this organization, it was formed a long time ago in 1993 to protect the indigenous people's right. At that time, indigenous peoples were not recognized in Nepal. So there's some pioneer lawyers, they started thinking that how the indigenous peoples would be legally recognized, because the problem of indigenous peoples that start from de-recognition of within the legal system. So they were not considered as a legal entity, so they did not have a rights, and so they didn't have the access to resources also, and access to justice, what we call. So that is starting. It was a good starting in the first place, so that the organization was successful to introduce a law in 2002 that recognized indigenous peoples in Nepal legally. That's how we started. But there are lots of historical injustices against indigenous peoples that need to be dealt amicably and legally. That's what we have been doing. This is one of the injustices is land displacement or displacement from land territories and natural resources that can be considered as a colonization to the indigenous peoples, and that's also linked to the human rights and also to the environment as well. Thank you.
I will give now the word for Ulianti Laba. You are a representative of the Sami Council, so could you please elaborate on the work that you are doing in respect to land rights?
Joo, Porpeivi Puokkaja. That is good day in my mother tongue, Sami language. Yes, so I worked recently in Sami Council in the Human Rights Unit, and as probably most of you know, Sami Council is I think the longest still existing indigenous organization that is established in 1956. And our work in Human Rights Unit of the Sami Council basically consists of two kind of major parts. First is the promoting indigenous rights in global level, and the second is promoting indigenous Sami people's rights in national level. And for example, promoting indigenous rights in global level, we participate in different kind of processes, especially in regard of the United Nations. Very important arenas are, for example, United Nations Permanent Forum on Indigenous Issues and expert mechanism on the rights of indigenous peoples. And of course, we are, for example, giving statements in regard of periodic reviews on treaty bodies and so on. And in national in those nation states that borders are crossing the Sami land. We are trying to affect on the legislation that are concerned the rights of Sami as an indigenous people, and of course we are then trying to assist Sami rights holders in different kind of cases that I think mostly are for example, land encroachment cases such as mining and, for example, wind power plants and so on.
Thank you.
Thank you.
I would like now to give the floor to Päivi. I know that usually we speak about the relationship between indigenous people and state, but there are also non-public actors, private actor, corporation, and organizations such as FIMFund, which have actually an important relationship with indigenous people. So if you could elaborate on that point, that would be nice.
Excuse me. Pleasure to be here. So I work for, it's a public development financier actually, FinFund. I'm sure many of you are familiar with FinFund, so we make development, we make investments in developing countries, so we are a financier, and we invest in developing countries only, so yeah. Just to clarify on that first. So I'm an environmental and social advisor, and before we start any project in developing countries, we make a very comprehensive environmental and social due diligence assessment, which we call a gap assessment. This is against the International Finance Corporation's performance standards, which include the indigenous people. So there's 8 standards, and one of the standards is particularly dealing with indigenous people. It is quite comprehensive, but also in addition to that, we have realized there are some gaps. So we also make an additional human rights risk assessment before we invest in anything. So this we have developed a tool for this. It's been a long process, and it's quite a comprehensive tool, which also includes biodiversity and water and other environmental aspects, but mostly it's on human rights, and it's looking at the potential risks and impacts before you actually make the investment. So sometimes you can see that there's a need for additional human rights assessment, and then you do that. So a lot of our work is actually preventative and not reactive. But of course, then there are situations where things evolve, and we monitor these things throughout the lifetime of the project. So that's in short.
Thank you. Yeah, and from what you are explaining, I can actually draw my next question, which relates to the importance of asserting a right to a healthy environment. So I'm wondering if, Shankar, you could elaborate on how this right, what this right means for you in your work. How does it relate to the right to land and natural resources of indigenous people in Nepal? Is it a tool that is valuable or that has not been valuable?
Based on our experience in Nepal, the land rights is the fundamental rights of indigenous peoples like across the world. Why it's a fundamental right for the indigenous peoples, because every rights that is connected with the land rights. You cannot exercise the right to life without right to land, right? You cannot exercise your right to life with the dignity along with the identity. That is guaranteed under the Nepalese constitution, but you cannot exercise that right unless you have the right to land. And also the indigenous peoples are the custodian of the land, and also they are the custodian of the natural resources. When we talk about the lands, we are talking about the holistic approach. We are talking about the surface, subsurface, and above the surface. And also we are talking about the natural resources, right? So when you talk about the indigenous peoples, the way of protecting land and protecting the nature, which is crucial, it's linked with the culture. For an example, I would like to share with the one indigenous community, which is the Magar indigenous community, live in the northern part of Nepal. They have like quite good populations. Actually, there are 59 indigenous peoples who are officially recognized in Nepal. So this community, they have a belief system that forest is their home, and the house they call is a cape. You know the difference, right? The house, what we call the home, that's the different, but they call the forest is a home, right? So that's why, that's how that we can understand how they take care of the forest and natures, right, in their culture. Let me give you another example. There is a nomadic group which is called the Dorothée. The government agency, every year, they bring into the capital what they call that showing this community to the nation, right? And they meet prime minister, and then they have like meeting with the prime minister, and then every prime ministers, when they come to visit, they say that they offer, why don't you settle in one place? Why do you roam in the forest, right? And they say, excuse me, Prime Minister, that's not the forest, that's our home. So we cannot stay in a city. When we came here 3 days, it's hard to breathe, but we can freely breathe in our place. That's why, and then how can I help you? Then clearly that the Dorothée chief says that, don't touch our home. We want to live freely. So that's why we have to understand that. Their way of life, if you think about the Dorothée people, what they do, they make wooden pot, and they cut down that kinds of trees which has no commercial values. That we think now that there are different model of protecting the forest that imposed by the government. One is the community forest. And the community forest is always look from the economic perspective. The trees and resources are the commodity. But for this Dorothée community, for indigenous peoples, it is not the commodity, right? So you have the right to protect the home, and the home will protect you. That's kinds of customary law and belief system they have. This has to be recognized in the law, the national laws. Maybe this has to be recognized in international law when we talk about protecting the environment or nature, or protecting, that we are talking about how we can overcome from this impact of the climate change, right? So maybe these are the things when we talked about the land rights of indigenous peoples. This kinds of concept has to be understood by the policymaker, by the environmentalist, right? And also that, let me conclude with saying that one example. I want to talk about the protected areas that has been highlighted as a conservation, protecting the animals, right? So in our experience, what we have seen that there is one national park, Chiton National Park, you can Google it. It was established in 1950. And at that time, there was enumerated the one-horned rhinos, because that national park, the government established to protect that one-horned rhinoceros. Their population was 1,000 after establishing that national park, within 6 years, if you looked about the data, the population of one-horned rhinoceros dropped into 360s. So whether these protected areas are protecting these natural resources or animal or indigenous peoples, we have to think about it, right? And now the government is saying that zero poaching area. I looked about their data. The population of one-horned rhinoceros is only 696. So that's why this is a serious question, whether indigenous peoples are protecting the nature, conservation, or this model of conservation is protecting, right? So that's why when we talk about the protecting nature, we have to think from the different perspective. This will benefit, not only I'm advocating the indigenous people's right, but what am I saying that if we are thinking about sustainable development, or if you are thinking about overcome or climate change resilience, it will give a different perspective to think about. I guess that this has been started. And let me think about it, that my organization worked to promote the international, the international laws such as like UN DRIP and ILO Convention 169 that Nepal is a party to. Now we are thinking that these two instruments can recognize indigenous people's rights and these kinds of system, especially as a right to be a custodian of land and natural resources that has to be implemented. Sorry if I take a long time. Sorry.
Thank you for highlighting those very valuable issues. And what I take also from what you are saying is clearly that the protection of indigenous people rights is also a move to protect the environment. And what we see is that at the international level, as you mentioned, there are already instruments such as the UN Declaration on the Rights of Indigenous People, ILO Convention 169, which recognize the environmental rights of indigenous people. So those key instruments should be further protected and implemented by states and other actors. And I know that the Sami Council has been actually on the front line, historically speaking, to push for the adoption of those instruments. But I'm wondering if you can elaborate a little bit more on how you feel about the role of the human right to a healthy environment in your work. How does it relate to your work? Is it a tool that can be used by the Sami Council to further strengthen the right of the Sami people at the international level or a national level?
Yes, thank you. And I can echo with many of the issues that Shankar already brought in his speech. Indigenous land rights are one of the core rights of indigenous rights, and as you mentioned, the United Nations Declaration on the Rights of Indigenous Peoples and ILO Convention 169 are those legal instruments that recognized the rights, also the rights of indigenous peoples. And as we of course know, the current situation now in Scandinavia, that Norway has ratified the ILO 169 convention, but Finland and Sweden have not yet ratified it. And of course, I can say that the ratification process in Norway is kind of, I mean, even if the convention has been ratified, the implementation, of course, is still ongoing, and especially in regard of the land rights, there is this kind of a temporary solution which is called the Finnmark Act, and of course the right to healthy environment is kind of threatened in the recent situation. If we think, for example, that there are many plans, mining plans that are targeting Sami lands all over Sapmi in Swedish side, Finnish side, Norwegian side, and also in Russian side in Kola Peninsula area, and as we know that how huge negative impact on clean and healthy environments this kind of large mines can have. They can pollute whole water systems and of course many materials that mining or I say minerals that mining industries are trying to use. For example, uranium is very dangerous and can have very bad negative effects, and then we of course come to the plant rights issue. I can echo as Shankar mentioned that, and that when the majority population come to area, they are talking about forest. It's your home. It's kind of the same in Sami land that, for example, in many acts and other official documents, in Finnish, it's most of the area that is in, for example, in Sami home region in Finland, it's called erämaa. So I would translate it in English. It's wild mark, and it kind of gives this kind of idea that no one is kind of living there, but that's not true, because that's the home of Sami people and their reindeer and it's the core foundation of the complete way of life of the Sami people.
Yes, again, very important issue that you are raising, and of course the issue is that in Finland we have legal frameworks that recognize the right of the Sami people, but as you mentioned yourself, either in Norway, in Sweden or Finland, the issue is always about implementation and how we make sure that those rights are respected in the development process. So this leads me to ask a little bit more about your work, because we see that one key issue in relation with the protection of land is also the issue of consultation in order to prevent that the damage already occurred. So I suppose that you follow specific guidelines, and you just were discussing the fact that you have specific guidelines in regards to development cooperation. So how far does it go, and what did you do in relation with the right of indigenous people, if anything?
Yes, there's always community engagement. So that's under the IFC performance standards that we apply. There is community engagement, that's the standard. But if there are indigenous people in the project area where we invest, then of course it is more comprehensive and very thorough, and there's an FPIC process, which is a free prior informed consultations. So all of this needs to be in place before you actually make investment decisions. But I'm inspired by my colleague here, so I would like to bring a positive comment to this, because I feel that FinFund is in a position to actually make a difference with development finance. And when you talk about forestry, we actually invest a lot in forestry sector, and sometimes the national legislation is not as strict as what the international standards require. So it is also an opportunity for us to actually help and assist in situations where the law is not as strict or is not implemented, and you can you can use your leverage to actually help people, for example, with land rights, to do boundaries and help them with authorities to actually mark your property. So we've done that in Asia and in Africa.
As a follow-up question and more concrete question, I know that in some cases, unfortunately, free, prior, and informed consent was not obtained because the legal framework of the national state is not strong enough, or the process was not. And I know about a specific case, which is the case of the construction of the wind farm Lake Turkana on Lake Turkana in Kenya, where FinFund was investing. And in this case, a judge, court in Kenya recognized that the process was not followed and that the land right of indigenous community was actually not respected, but the wind energy project was nevertheless built. So in that regard, once the damage is established, I'm wondering what is the responsibility or what is the role of FinFund in remedying those issues?
Yes, of course. No, it is. These are challenging environments, and they are not easy to work in always. And of course there is a remedy aspect if things go wrong. Yes, for sure.
Looking at the time because we are already past do I have a couple of minutes more? Yeah, so because I know remedy is such an important issue because unfortunately we cannot prevent all damages. So I'm wondering if you had anything to add in relation with remedial mechanisms that could be used aside from court. Is there anything in your experience that can be used within the indigenous community to help remedy those damages?
Thank you very much. Important questions, right? Because when there is a human rights violations or indigenous people's right violations or whatever the irregularities, that how we can get the remedies. There are two kinds of remedies in our context in Nepal. One is formal, that is the state court. We bring a lot of litigation and we have got a success in some cases, but not in all cases. There are so many technicalities. Another thing, from the access to justice perspective, the indigenous peoples, they are living in the remote area. And those state mechanisms, like a Supreme Court is in capital, and the high courts are located in the city, even in the provincial courts, right? So the indigenous peoples living in those areas where there is no transportation, you have to walk like 3-4 days, then how can you ensure the access to justice? In that regard, the indigenous peoples, they have customary justice systems. That is not well recognized. So what we call in the legal term, these institutions are de facto recognized because these are functioning there generation to generation. They have easy access, they can deliver the justice. I'm not saying they are perfect. There are things that has to be the changed in the present context. But it's very easy. So that's why, let me give you the one example maybe that makes it clear. There was a very simple ways that you can bring the complaint in these kinds of mechanism. You don't need to pay a court fee. You don't need a lawyer. You just go and tell, because communities, they have like system, they know what's happening there. They are the witness. They know the proofs and everything else. So it's very easy if some wrongdoers, they can easily confess that what happens there, right? So and they clearly monitors and the decision, and mostly it's a restorative justice. If you looked about the decision of the Supreme Court, the record shows that 60% of the decision it's not implemented. So there is gaps. So fulfill that gaps, there is alternative mechanism that has to be recognized. I guess the two international instruments, UN DRIP, ILO Convention 169, as our colleague mentioned from FinFund, there is alternative that can be recognized, but it's not only the government has to recognize, but the other international organizations or international partners. In that regard, KIOS and Lahore we are doing some sort of studies, and we came up with some studies that shows that there is a the potential things, and then that can fulfill the gap. Right. Thank you.
Yeah, thank you for this comment. I think we will now end this session, but what I take from what you are saying is that there is really an important statement to be made, is that national legislation are unfortunately really lagging behind and are not enforcing or protecting or implementing well indigenous people rights, and this is also the case in the Nordic countries, in fact. So we need really to reinforce international standards, to put pressure on national states to improve those framework, and also to create space for indigenous people rights and law and system to be supported and protected at the national level. There are many issues that I wish we would have the time to discuss, but unfortunately I think I have to end this panel session. So thank you so much for joining us today. And I hope we can continue the discussion around coffee.
Thank you all. And as Dorothée said, we will have now a short break of 15 minutes. So here in Helsinki, it will be about 11:22 when we will come back to this hall and continue the discussions. And those here in the hall, there's also books from KIOS Foundation and Siemenpuu Foundation for free that you can take with the coffee. But first, of course, for the discussions together. Thank you.
fancy coats.
Thank you.
I mean, both of you.
Pattern.
Oh, it's very beautiful.
So welcome back to the seminar. We now have the third discussion today, the panel discussion. And may I introduce Anu Tuukkanen, who will moderate the discussion. Anu is working at the Amnesty International, the Finland section, as a, or you could say, you know best your title there.
Yes, I work as an expert on human rights defenders and civil society, so very fitting people we have here now. So, welcome to you all. It's wonderful you have you here, and we have already heard from Matti, and we have heard from Shankar, and we also have introduced you earlier, so we'll not be doing that again. But Iris and Tom, you are new to the panel, so it would be great to hear a bit from you. So maybe before we start talking about this issue we have at hand, which is protection and support for environmental defenders, security issues, challenges and opportunities. That's our topic today. So would you please, Tom, introduce yourself shortly. We already heard about your, from Phyllis about what your organization does. You work for the Center for Justice, Governance and Environmental Action. But if you would briefly tell us a few words about your role and your work in the organization.
Thank you so much. So at Center for Justice, Governance and Environmental Action, I'm the programs manager. So I am in charge of running all the organization's programs, the projects, and coordinating all the other staff within the office. Yeah, so that is my portfolio in Center for Justice. Yes.
Okay, thank you. Iris, you are an activist at the Extinction Rebellion and Elokapina in Finnish. You're also an artist. So can you tell us a little bit on how you combine your art and your activism?
Yes, my name is Iris, and how do I combine art and activism? It's been a struggle lately because I have found a crisis in making art. I think lots of time is put into what is not so necessary in these times of crisis. I do study dance, but then a lot of time goes into like direct action and maybe educating myself on how to effectively act right now. But at the moment, I'm actually found a way that inspires me and is like, I find empowering. We are working on a project at Ylioppilasteatteri, which will take place in June and July. And we are now inviting people from different environmental movements and the, what is the AY-liike? The
labor movement.
Yes, this trade union, yep. And also some political parties to discuss together how to like make some joint action to stop the Helsinki city politics that are actually just accelerating the crisis and not taking action. So I think it's like art through discussion and like how to make theater from that. Yeah.
Thank you. So artivism is your bread and butter. Great. So at this session, we'll first discuss the challenges environmental and indigenous defenders face. And then we'll look at what kind of support and protection is available for you, what tools you have, and what you need. And lastly, I would like to hear your concrete recommendations to Finland, first of all, and maybe other actors as well, maybe EU, businesses, whatever you want to bring forward. So let's start the first round.
Johanna Sumuvuori, State Secretary, already kind of took my burden because I was going to say about the same things that she already did. But very shortly, environmental and indigenous land defenders are often targeted for their work, and they face retaliation because they expose human rights violations by corporate actors and other actors, states. And we can, for instance, the example of that, more than half of the human rights defenders killed last year were people doing this work. And it's been kind of documented by different NGOs, Frontline Defenders, Global Witness, and so on. There are also, for instance, examples of killings in Kenya of environmental defenders and also kind of abuse in Nepal. The retaliation also takes other forms, not only killings and physical violence. There's also smear campaigns, verbal or physical intimidation and violence, surveillance online, offline, criminalization of activists, destruction of property, discrimination in employment, for instance, and other things. And another thing also is shrinking space for civil society. That's maybe something that is more topical for Finland at this context, but restrictions to freedom of assembly, association, speech, so that's very topical also, I believe, in your environments. So we have a very broad range here to talk about. I would like to ask you all, how would you describe the security landscape for defenders in your country? And what specific challenges do indigenous and environmental defenders face? And you can also tell some examples. You can tell about your own experience, your NGO's experience, or the community's experience. And I hope you also comment on the state of civic space in your country. For instance, the restrictions on freedom of assembly and so on. Maybe we start with Shankar. If you tell about the situation in Nepal.
Well, thank you very much. This is also the crucial areas that how we can make sure that the human rights defenders or community rights defenders, they are safe and they are secure while they are defending the rights of the communities, or they are defending the land rights and also defending the environment rights, right? The first challenge what we have seen is the recognition of human rights defenders. That is because the police and the government, even to the human rights organizations who are working in a national level, they are reluctant to recognize the indigenous people's right defender as human rights defenders, right? So that's why, if that means what it means in legally, that means that they can be put in custody, jeopardizing the peace and security in the society in the first place. So there can be the charge of fake cases. So we're sitting in a capital, and then most of the time we go to the community as well. But when we go to the community, then we also face a kinds of direct and indirect intimidation as a lawyer, right? We know that how to fight against it, but you can imagine that those community people, when they are not aware about these kinds of right, then what kinds of situation they face it. 2 weeks ago, one woman, she was just saying that it was about the transmission line case. The transmission line, the laws clearly says that you cannot take above the houses in human settlement, which is crystal clear in the law. So she was saying that, why don't you avoid my house? Because this transmission line is supposed to go from the safe place. She was not against that project. She was arrested. She was tortured and hospitalized for almost 3-4 days, right? So, and then what we did at the same time, we called to some of the organizations. It's not nice to take their name, but they said that she's not a human rights defenders, right? So we have like two kinds of human rights defenders working in the community. One, we provide identity as a human rights defenders, right? So that's why they can show their identity card whenever they go. That's also the one strategy we applied. Another, we work very closely with the national human rights institutions, so NSRI, if there is something going to be happen. Because we have to be careful that how we can prevent the human rights violation. Not like there is a human rights violation and you can take a remedial part, right? So that's why it's our duty. So that's why we work very closely with the national human rights institutions. The another very, very important the organizations or important our partners like KIOS and then like UN and then ILO. But I often like to prefer to like the organizations like KIOS and CJGEA and Amnesty International, because the ILO and UN is very bureaucratic, right? So I'm not criticizing, but that's the technicality that we have to do that one. That cannot provide their service in timely manner. But the special rapporteurs are something different. We are using them. And the third one, for preventing human rights violation, code of conduct is very important for human rights defenders. So that we have a kind of code of conduct, develop a code of conduct that how they can support to the community, right? And also we seriously take our responsibilities to those indigenous leaders who are actually defending their rights in the community, especially land rights and environment rights, right? So that's the one. And this last course, if maybe if there is a human rights violation, then we can use the court as well and national human rights institutions and international human rights bodies. Yeah, thank you.
Yes, thank you. Tom, you'll be next. Yeah. So, about the security situation, and Phyllis already told in the previous discussion a bit about the situation in Kenya, but maybe you can also elaborate a bit on civic space.
Okay. Thank you so much. So, for the Kenyan situation, I would say that the security landscape for the land and environment defenders is not that good, because defenders mostly work at great personal risk and the risk of their families. You will find that in Kenya, in 2015, Kenya voted against the United Nations General Assembly resolution on the protection of human rights defenders. This already underlines the fact that Kenya is not ready to protect land and environment defenders. In 2014, Kenya amended the laws to the Public Order Act through what we call the Security Laws Amendment Act. And the 2010 constitution for Kenya is a very progressive constitution. It provided laws that could protect defenders and also allow for freedom of assembly and rights to picket and freedom of association. But with the introduction of the Security Laws Act 2015, you find that most of these clauses were amended, and this in a way curtailed the freedoms that LEDs could enjoy in line of their duty. And the civic space has been shrinking. The 2020 report by Global Witness ranks Kenya as one of the most deadliest countries for the land and environment defenders to exist in. And so the landscape, the security landscape is generally not that conducive for the land and environment defenders. Some of the challenges that defenders face include security risks and threats. The most notable one is criminalization of defenders, whereby you find defenders who rise to challenge human rights violations or environmental rights violations within their communities are criminalized and accused falsely through bringing of fabricated charges and through judicial harassment. Just as Phyllis had mentioned, we have many defenders who have been criminalized and judicially harassed because of standing up for their community land rights and environmental rights. A good example is the LED that is working in Kwale against an industrial establishment that is recycling oil to produce other products. So this lady rose to challenge the environmental rights violations that were being meted upon the community by this industry. And she met a lot of retaliation from both the industrial establishment and the state itself, because you will find that in the management ranks of this industry, there are very powerful people who have good connections within government. And so they have used this to their advantage to bring very many false charges against this lady. And as we speak, she faces up to 6 criminal cases at the courts, in the courts of Kenya. And this has been extended also to some of her family members. And I think this is a tactic that is being used to try and dissuade her from continuing to pursue such causes that she was pursuing before. And this has also been extended also to the other community members that she was working closely with to try and raise some of these issues within the community. So that is one of the security issues. Another one is defenders face very huge challenge in terms of inadequate resources. You will find that most of the funders and the international organization, the donors, tend to channel their funds towards conservation projects. And this leaves the defenders, those who specifically work on land and environmental rights, hanging in between. So this inadequacy of resources to continue with their work effectively means that they cannot grow, or even they cannot challenge some of these situations that they are facing. And so there is need to at least look into the issues of funding, and donors and international organizations should kind of do some review and perhaps also include the issues of land and environmental rights more into their scope of work and funding areas. Yes, thank you.
Yeah, thank you, Tom. You both brought up kind of very important things. One of the environmental indigenous defenders not maybe kind of seen as human rights defenders, and especially if they are kind of working on very grassroots level, so that's even more difficult. And also the funding issue, this maybe affects also that. So security, your opportunities or possibilities of working depend a lot on the recognition issue. So you should be recognized as human rights defenders, which is already kind of understood as a legitimate role. So thank you very much for that. Maybe we can continue then to to Finland, where we face very maybe different issues. I mean, some of the same, but also very different. So Matti and Iris, so the security situation in Finland is definitely different, but many activists still face harassment, face threats, especially online. People have been kind of silenced. They don't want to work there because they get so much hate speech against them. So what kinds of challenges activists and defenders face in Finland? And maybe if you can also touch upon the civic space thing and what you think about freedom of assembly, freedom of speech, how it affects your work.
Okay, thank you. Yes, well, first I want to note that Extinction Rebellion and Elokapina in Finland operates from a really privileged position, as it consists of white people and belonging to the majority group in Finland, like the valtaväestö I'm speaking. But even us who are going to the streets and disturbing the business as usual, the protests are treated as safety issue by the police. And this is already like a challenge and even a threat to the right to demonstrate and the right to speak up. And also like the notion or the knowledge and experience we have of the police sympathizing the far right people or the far right messages is like must be taken into consideration, and that like because we know that the far right being present when we are protesting, it already excludes so many people from the movement because it's so threatening to them, and while police not actually doing anything for their disturbance. In fact, we have experience of the police like telling a far right person how to harass us even more. And that's like, that is happening in Finland, where people do trust the officials and the police. The protests are poorly protected, as that mentions, and like we have experience of cars passing through a block and there were police standing by and nothing was done. Yeah, I think it's also a threat that we lack resources in Elokapina and this movement to like make cases about the inaction by police and like really talk about this, because we're so occupied with like even like making up the protests and all that other work. So that would need more resources. Yeah, and I wanna like say thanks to other civil movements that are very on the left, like in Helsinki, and people in Finland might know Varisverkosto and the anti-fascist movement, who last summer they actually protected us more maybe than some of the officials when the far right was there, because they have knowledge like how the far right people operate and where and who they are and like what to do. So civils are like protecting each other, I think.
Yeah, so what to add, I think our perspective is a bit different, that in general we use only those legal tools that are given to us. So we defend nature on the paper, so but still we get like indirect attacks to stop doing that. And it's our association is nationwide. We have 150 associations all over the country, and we have regional and local associations. And those who work in the local associations, they are usually volunteers, and they have, of course, civil jobs and works as too. And I think it's more common to try to affect to the defenders through that they work or social media stuff like that. They get a lot of threats to they will lose their jobs or affect all their children through that. So that kind of threat we have, and we have one or two direct attacks, like this one mining company wants to get criminal prosecutors for our members, like 10 years ago. And this year we have like very direct attacks in social media in this Sipoo area. That was really, it was about housing rights, house building rights. So not a big thing, but they really can like build up hate towards our association. But there's still that this, I think this kind of discussion has to happen in Finland too, that Finland usually think that it's really, we are so small country, not lots of people, so everything is calm, but it happens under the surface, I think, more. But yeah, I think that's one point.
Yes, thank you. So you kind of refer to a little bit to a kind of a chilling effect that the resistance has to activists. Like you said, not everybody wants to go there to demonstrate because they are afraid of the far-right groups. Actually, Amnesty Finland just gave a statement to the Finnish Universal Periodic Report, the UN Human Rights Council process, and we stated that maybe for instance, the charges against Elokapina activists, the disproportionate charges they got last year when they were demonstrating on the government palace. So that might be something that would create a chilling effect and maybe arresting people also for no good reason. So that's something we see here, and I think that's something very globally happens. You also, I think, maybe somehow internally hinted to gendered or racialized harassment that might be combined there. I would like to ask you all, from the kind of intersectional perspective, because kind of you're working with very marginalized peoples, and also you're working with communities, and your kind of partners, and so are also kind of, maybe you're hinting to that, saying that racialized or people, for instance, are not very, very eager to come to your demonstrations because they are afraid of retaliation. So would you like to comment on that perspective? How does it kind of, how do you see that in your work? An intersectional perspective to human rights defenders, women, sexual, gendered minorities, racialized minorities.
Well, I can say one thing. We in Elokapina, we actually got like a wake-up call for this, more like to look at our own actions from more intersectional perspective by like a Sami activist and another activist in Finland, and it was really like precious comments to us, and it opened up like new possibilities to do like anti-racist work in our community or in the movement, like how to make this more inclusive. And yeah, so that's like one thing where like every time now we've tried to make like protocols that we follow when we are organizing an event, that everyone is aware of their privileges and how to like operate in the shared space so that it would be safer as far as we can take it. And we have these support people always, like in roles when we are protesting. There are like police contacts and law support people who are like observing what the police does. And before all the protests, it's now like a rule that the people must go up to the police and be like, you know, we are actually following how you treat the demonstrators, because I think like there is a lot of racism in the police institution and like in the structures we live in here in Finland. So, and they are not like opened up. Nobody is educating the police of how you what you're doing and what like informs your actions. So like it's I don't know, we're desperately like trying to do what we can to like tell them that you should be aware of it. And I don't know what would be the tools to like increase like the knowledge of the police, the knowledge of racism and other forms of oppression in the police, because it's such a like a system that is so far away somehow, and who makes those laws and
Maybe okay. So Tom and Shankar, do you want to comment? I mean, we almost had an all-male panel here, where, and then fortunately we got Iris here. So maybe the gender perspective. How about the women defenders in your countries?
So, for Kenya, we work very closely with communities, and in these communities, women are the most supportive in our courses, and you will find that they are always at the forefront when we advocate for issues, especially for on environmental rights and land rights, because women are the ones who are most affected, women and children, by some of these violations that these industries and development structures and so on met on them when they are being established. So women are always very vocal in the struggles, but also we work closely with the different agencies, government agencies, especially like the police nowadays. Also in Kenya, it's a requirement that when you want to protest or to picket or to just conduct a peaceful assembly or a march, you have to notify the police. But again, in Kenya, this law has kind of been curtailed, because nowadays it's not very easy to get permission from these authorities to either march or picket, because they always find a way to throw away your request. Like recently, I remember when we wanted to conduct to picket in the community, we put a request to them, but then this they turned down, giving reasons that there were security issues within the coast, and so our demonstrations could not continue. But again, you find that in our constitution, we are assured of the right to picket under Article 37, and so you find that these laws are conflicting, and the constitution is the supreme law of the land, but the police some kind of have their way to deny you some of these rights. So I would say that we continue to engage them, especially in the forums that we always have, to view some of these initiatives that we undertake as not being always against the law or against development, but as a progressive way for upholding the citizens' rights, and also developing the civic space within the Kenyan nation. Yeah.
Thank you. Shankar.
Yes. As I mentioned earlier, that there is no recognition for human rights defenders, but at the same time, we are facing the challenge. The collective rights are also not recognized as a human rights in national arena. That also impacting to the largely in contributing to the human rights violations, right? The third one is, but very important things, how indigenous women are, their rights are being respected, or if there is a their rights is violated, how that has been taken care of. In first place, indigenous women are not legally recognized in Nepal. That has a severe impact in many areas. Okay, let me give you the one example. It's about the national parks. The national parks are, most of the national parks in Nepal established in indigenous traditional homeland. And the women are the guardian and custodian of natures. And also they have responsibility to take care of their family. And most of the women, men, they go outside to work because they were displaced from their lands. And it's very difficult for livelihood subsistence. There is no choice for the women. They have to enter into the forest. I remember that last year Amnesty International came up with a very good report that one woman was giving testimony. This is our land. We go to collect the forest. The forest production, non-timber forest productions, vegetables, or whatever. Then entering our land, in our own land, how that action becomes a crime. That was the powerful statement that was mentioned in the Amnesty International report, right? And the national park guards, they treat indigenous women so, badly. Sexual harassment and rapes and misbehave, ill treatments, that is routinely basis. We went there to study, and then in our study team, we have one friends, colleagues with female colleagues, and then she interviewed with victims, right? And what the victims, they told that, because they face that kinds of sexual harassments routinely, on daily basis, and they don't complain. Why? Because nothing happens. There's no point to complain against the army, against the security forces, right? So, and also that they told that how this situation can be changed. There is one possibility. If the forest guards are, they appointed from our community, who knows us, maybe these kinds of harassment would be stopped, right? So the national parks in Nepal, that is, the security is given to the army. So the army, once a year, they change. Whenever they go there, that they badly treated to the indigenous women, right? So these kinds of situation are there. But importantly, what we do is very few organizations, human rights organizations, bring these kinds of issues in their report. So it is very important to prepare the human rights report that reflects the collective rights violation and violations of indigenous women's right, right? So that's the important thing, I guess, important thing that we have to think right at the moment. And then the impunity. So there is so there was one case, the woman was attacked by army personnel. He wanted to, that was the case of attempt to rape. She opposed that one, and then that army personnel hit her so badly. Now she is almost paralyzed, and then she could not walk. And then how much compensation was given? The compensation was, it was like 10 kilo rice, 5 kilo potatoes, and 2 kilo dals. So you can imagine that what kinds of situations there, right? This report has been published by BuzzFeed, the international, and also this has been the report. We published about that report also, right? So that's why I rightly pointed out that when we talk about the human rights violation in general, we maybe forget about those kinds of things which are very important. Right?
Thank you all. I think we have to move forward to a bit to the tools and the support mechanisms you may have in place. But just a short there are very important things you raised. One which seems to be common to all is the actions of law enforcement troops, both maybe in Finland, also in Kenya, also those protecting or providing the security for the national parks maybe is not unproblematic. In Nepal, what we heard. So that's one very common thing, and the intersectional approach, very important. And what Tom, you said about families, that's also a very key, and that also connects to women being defenders and needing to take care maybe of the families more than male human rights defenders, maybe more easily doing that. So that's already a very good things we have discussed. I was maybe going to ask you about SLAPs or strategic lawsuits against public participation. I think you touched upon that already. So maybe we just note that these happen. So tools and mechanisms. So there are different tools and mechanisms to support supporting and protecting defenders. And I would like to raise now one. There is the EU Human Rights Defenders Guidelines and Finland's own guidelines, which the State Secretary already mentioned in her speech. And you have already talked about UN special procedures and national protection mechanisms are in place. There are regional networks. You have already mentioned NGOs giving some support. So maybe if you summarize very briefly, what you think, Tom and Shankar, would be the most important tools that are available to you, and what you think how to make them even better? Yes, you go first. You have the mic.
Yeah, so for us in the Kenyan situation, we have different tools that we leverage to protect our defenders. One is the courts. This is in the 2010 Constitution, the Kenyan Constitution 2010. The Environment and Lands Court was introduced, and this court has given the land and environment defenders the opportunity to litigate some of the environmental rights violations and land rights violations issues within their communities. And so far, so good. We can say that it's doing a much better job, even though the litigation process is a bit long. But then at the end of the day, we have that option to go to court to challenge some of these issues. The second one is the international organizations, such as the UN procedures and other funding organizations that work closely with the land and environment defenders to protect them and provide security for them in cases where they are at risk. We've partnered closely with international organizations such as civil rights defenders and frontline defenders in protecting some of the LEDs that we work with closely. The third one is the networks that land and environment defenders create. So through the partnership of KIOS, Center for Justice has managed to establish a national network for the land and environment defenders, which has brought together the land and environment defenders community to under one umbrella, where they can advocate for land and environmental rights issues as a united front. This in a way also legitimizes their work and also provides a sense of security around what they do, as opposed to when a defender is working in isolation. So those are some of the tools that we've leveraged so far to protect our defenders. Yeah.
Shankar, go on.
Yeah, lately we have been dealing lots of cases relating to the development aggression, and where not only the national level actors are involved, but some international financial institutions also involved, right? Maybe it's good opportunity to mention about that one case that was supported by the Finland government. It was in Nepal to establish the waste management project. It was a grant from Finland government. So the people, they also agree first about the project because they were told that they're going to build the hospital and schools, and that's why. But later they discovered they are going to build a dumping site, bringing the garbage from the 4 major cities in the eastern part. So there was a huge conflict between the project and the communities. And the government, the local government was in the mood of deploying the security forces already. They deployed for 2 times. And so it was almost the border of India and Nepal. So the area was very sensitive, right? So the issue came to our office, and then we went there to talk with the community, and the situation was so tense. And we talked to the government authority. They said that even we will, if it deems necessary, we will open the fire. That's what the government position. So what we have to do that one, I mean, I'm just indicating that not only the available tools or mechanisms, maybe we have to explore in this situation. So the strategy is very important that I want to flag on, right? So we approached to the Finland embassy, telling about this situation. It was so good that the ambassador was very positive. And then we had a meeting, and then sent some expert for independent study. The report was very comprehensive, and there was a series of violation and that not respected the human rights. And that was consortium project. There were other European countries also involved. So the project was stopped. So everything was fine, right? So that's why maybe these kinds of situation where international actors or international communities are involved in development activities, maybe we have to approach them. That's also the one of the things, right? What we are doing, in the previous discussion, we discussed a lot about the free, prior, and informed consent. So that right has been enshrined in various international human rights instruments, and also there are guidelines as well. Let's say, for an example, World Bank and ADBs and EIVs, they also have safeguard policies we can use as a tool, that one. And also the court, as a practicing lawyer in our experience, I don't really prefer in the first place to take the litigation or that sort of things, right? Because there are so many challenges. I understand about that one. I cannot disclose in here, right? But the better thing is maybe also these kinds of international human rights instruments and human rights mechanisms, right? And like special procedures, including the business and human rights, right? There is a business and human rights forum in UN. Also, we can approach about it. And also we can bring the complaint to the safeguard mechanisms of the financial institutions. And also that I would like to point out that maybe it is important to have a wider networking with like a KIOS and Amnesty International who can support, right, in a timely manner, and then they have a capacity to produce like credible human rights report that can be used in this situation.
Thanks. Now we have already kind of passed our time, but I would like to have a very short last round with you with the recommendations. But first, kind of, we have seen here there are different tools ranging from the UN mechanisms to very, very practical things like what you do in your demonstrations with Elokapina, like you have the roles and you are trying to make the space as safe as possible. So there's a whole range of things you can do. Now we have a wonderful opportunity to address the Government of Finland here, because Rauno is representing the Ministry of Foreign Affairs, and and I hope he has a pen, because now I'm going to ask you to give your recommendations. So very shortly, I mean, you can touch upon very kind of broad things like legislative processes, like for instance the EU Corporate Sustainable Due Diligence Directive, or you can go to a very practical side. What would be your recommendations to Finland especially, EU through that, and if you want to other actors, like human rights organizations, for instance?
Thank you. First, I would say, like, join the battle, really. Like, recognizing a right to healthy environment is great, but it's like nowhere near enough. I think, like, isn't that the obvious recognition? It should be made a law that no one can violate. So, like, recognizing who is doing what, that makes this not take place. Like, people even living here in Helsinki, where things are going well, I don't feel like it's a healthy environment or safe for people. So I can like only imagine what is happening in the environments like elsewhere. So recognizing what the structures are that are maintaining the system, and like joining the battles. I've lived in Palestine, and now I just want to shortly comment on that. I've seen these videos that are really terrible, where straight violence is put on indigenous Palestinians, where Israeli settlers are taking the homes. Like, why is this happening still? We have these roles of peacekeepers in war areas. I don't know what they do, but why don't we have roles or people like located in the places where the environment is violated and homes are taken from people? Is it because the states are part of this colonialism, or like maybe we need the privileged structures or privileged people to be there observing what is happening and how the environment is like violated and people's lives maybe. So something like that, this observation done locally should be also made public, and like more media coverage should be, like people should be aware of what is happening and what colonialism means in the Sami land. Like the mainstream doesn't know anything. I don't know enough about it, and I'm trying to put time. So it's like really hard for the majority of people to know. What does it mean to join the battle if the aim should be that activism is not needed? Like, I don't know if that's the target at the moment. Are the institutions only making it more safe or more possible to be an activist? Like, I think that's a problem. We should get rid of the need for activism, and the structure should be there battling against. And what are the tools for that? Maybe a role of a peacekeeper telling that you cannot take someone's home.
Shortly, a couple of easy things would be that secure the access to justice in any cases that have environmental impact. So there's still corner cases that we have to fight for it, and it always raises the questions: should we appeal? And all the communities can be seen as a harm making that we are making the appeals. And I think one would be I would always talking about the EU, but the EU's environmental criminal directive should be implemented to how the Commission proposed it. It would be like lift up the environment criminal crimes to the same level as different crimes do in Finland, because nowadays we just think about it as something leaks or somebody dumps something somewhere, and usually it's by somebody just tries to get something like they don't want to pay it, so we should lift the bar for criminal crimes a little bit more. So that would be the easy cases to start with.
Thanks. Tom and Shankar.
Okay, thank you so much for being here, first of all, to come and listen to us. In the case of Kenya, I would say I had, you mentioned that Finland is in the Human Rights Council. Yes? Yeah, so one of the things that Finland can do for us is that you can help monitor closely the human rights situation of the land and environment defenders in our country, so that we help raise these issues of insecurity against the LEDs at the highest top organs of the UN. This, I think, would go a long way in helping to protect and secure these frontline defenders that work to save the planet. Secondly, we would like to see more partnerships, especially from the Finnish government, on projects that are geared towards protecting the environment and also enhancing human rights, especially those that are being implemented directly by the land and environment defender organizations and the human rights organizations. The third one now, we would like to see again the Finnish government refrain from funding some of these development projects that degrade the environment, and fund more projects that would actually conserve our environment back at home. On businesses, we would like to see more. This might not directly be to the Finland side, but we would like to see more engagements between the corporates and the LED community, in that we would like to see these people have more discussions regularly to try and discuss some of these issues that come up, or the conflicts that arise between the land and the environment defenders and the businesses. For example, what we are doing now, we'll be holding a forum on business and human rights, whereby we've partnered with both UNEP and the Office of the High Commissioner for Human Rights, just to bring together corporates and environment defenders who work on extractive industries, to come and have discussions and forge way forward on how to address some of these issues that lead to conflicts between businesses and human rights. Yeah.
Thank you.
Well, first of all, I would like to thank to the Finland government this morning and now in the session that I present here. I have some specific expectations, or not the recommendation, right? Because the Finland government and Finland, it's very good to know that Finland government has a clear policy towards to the defending the human right defenders, and also to the environmental justice. It has also a strategic paper and in the cooperation and the development of Nepal, which is, I have seen that more comprehensive, and that also touch upon the exclusion issue of indigenous peoples, women's, and other sections of the societies in Nepal. That is very good. I have to really, I think that when I read about those papers, I was invited in the discussion meeting by the embassy, probably KIOS coordinated for that one. And I also, but at the same time, when I looked about that paper, maybe a little bit more specific focus should be given to the indigenous peoples, because when I go through the whole paper, it mentions about that one, but for the implementation part, there are some provisions that is needed to substantiate that's the policy in reality. And there are some projects which is about the hydro project. The Finland is involved in, and that projects were being built. The hydro projects are being built in indigenous territories. I didn't see any complaint, or I haven't, received any information. But I know about that project is going on. And I'm sure that the policies that what we have been discussing here, that is not reflected in the project. Maybe it's one area that the Finland government can think of. And the last one, this morning also in the deliberation, we heard that Finland is a member of Human Rights Council. At the same time, Nepal is also the member of the Human Rights Council. So as a being the member of the Human Rights Council, maybe the Finland has more space to encourage Nepal government to respect the human rights of indigenous peoples. And for that regard, what I see that KIOS and the indigenous peoples of Nepal, like organizations like my organizations and the Finland government already can work in what you call in concert, right? In harmony, that to substantiate the human rights that has been respected, the collective rights of indigenous peoples is respected, the land rights, what we are talking about, the rights over natural resources of indigenous peoples. One thing that I would like to mention, that when indigenous peoples talks about the land rights, that we have to understand we are talking about the connectedness and coexistence and collectiveness. So it's not only that we're talking about that land belongs to the indigenous peoples. That means, yes, it belongs to the indigenous peoples, but it can be benefited to all sections of the society. Maybe that one I would like to highlight here. So thank you very much.
Thank you very much. We have gone over time, but thank you for your very important views. I just want to say maybe 3 words to end. So we have to learn, we have to recognize the land and environmental indigenous defenders, and we have to cooperate. And thank you very much for this discussion.
Okay. Yes, as Anu said, we will be running a little bit overtime, or planned overtime, but I hope it doesn't matter you. And I will now ask Rauno Merisaari, Ambassador for Human Rights and Democracy from the Finnish Ministry for the Foreign Affairs, to give a commentary speech. And hopefully we'll learn more about what Finland is doing with the membership in the Human Rights Council also. And perhaps you can reflect a little bit what was now said to Finland. Also recommendations from our panel. I have to also say that there were some questions also raised in the chat in the YouTube concerning the indigenous people's rights of the ancestral lands and territories in protected areas. I hope we can continue that discussion possibly later on. Then there were also discussion about the Convention on Biological Diversity, how it obliges states to regulate all corporate processes and activities with significant adverse impacts on biodiversity. And then how the EU Corporate Due Diligence Directive is not really taking this point on. And that might be something also for Finland to continue to work on, that would be taken more seriously on EU level also, and the corporate due diligence. Yes, but Rauno, now floor is yours, and possibly you could change the role.
That's better of these two options, yeah. Okay, dear all, thank you. Thank you, you of inviting our ministry to this high-level seminar on a topical issue, and thanks for previous speakers of your recommendations to our government. However, Anu, I must say that this is maybe a little bit unearned increment, ansiotonta arvon nousua to Heta-Elina and me and Riikka and Maija, who we are from the government, that we are supposing that we are representing the whole government, but we are trying to somewhere convey your messages to our colleagues, of course. My sincere thanks to organizers. KIOS is a long-term partner to MFA, and we value its work in promoting human rights, especially the rights of those who are in the most vulnerable situations, and in supporting human rights defenders, including local environmental defenders. And a particular value of Siemenpuu Foundation is their approach of promoting local capacity, agency and ownership and environmental justice. And my colleagues Riikka and Maija knows much better than me how this cooperation between our ministry and you works today. And thank you all of this wonderful morning. So very excellent speakers. I'm really delighted to listen to you all. I was asked to tell you about the Finnish government's perspective to the UN Human Rights Council as a tool in defending and promoting human rights, including a right to clean, healthy and sustainable environment. However, let me, in addition to that, say some words about our human rights policy, strategy and priorities, and about our support to human rights defenders. The government issued its human rights policy report in December last year, and the report outlines the government's policy in international, European Union and national contexts. So we aim to strengthen coherence at all these levels, including our homework on how to implement better fundamental and human rights in Finland. Finland promotes respect of international law and strengthening of the international rules-based order. And this includes respect and implementation of provisions of both human rights and environmental conventions and treaties. And it also offers a comprehensive and legally binding system to strengthen interlinkages between human rights and environment. The government report emphasizes the importance of the work conducted by human rights defenders and of human rights responsibilities in business. Supporting the activities of human rights defenders is an essential part of Finland's human rights-based foreign and security policy, and it includes also in our development policy as well. In particular, Finland emphasizes support to work for the rights of women and girls and of the population groups in the most vulnerable positions. We take account of themes the significance of which are growing in Finland's human rights policy, that is digitalization, environment and human rights, and corporate human rights responsibility. This State Secretary Sumuvuori already told that environmental human rights defenders are at the front of the climate and environmental crisis. And Finland condemns violence against environmental human rights defenders and supports their capacity to act. Over 200 environmental human rights defenders were killed in 2020, as our State Secretary said, and this is really unacceptable. Finland contributes financially also international NGOs for human rights and environment. Our support to Business and Human Rights Resource Center highlights the role of business, including renewable energy and mining sectors, in playing an instrumental role in tackling the climate crisis. The imperative to reach our Paris Climate Agreement goals and achieve a net zero carbon economy can only be accomplished quickly and effectively if human rights are respected through a just transition. This project works to support local civil society organizations and communities, including women and people with disabilities in 3 target countries, that is Kenya, South Africa and Mozambique. We also support Frontline defenders, the name was mentioned here earlier. Frontline defenders project for human rights defenders, while a considerable part of killings of the defenders are happening in the context of extractive industries and state-aligned mega projects supported by international investors. The project aims to hold states, financial institutions and business actors accountable. Business need to ensure that the human rights defenders and community leaders are protected from harm, particularly when business interests clash with human rights, such as right to healthy and clean environment and the right of indigenous peoples to free, prior and informed consent. According to our strategy, we stress non-discrimination, gender equality and participatory rights in a consistent manner. Finland cross-cutting themes in the UN Human Rights Council are the rights of women and girls, rights of indigenous peoples, the rights of persons with disabilities, and the rights of sexual and gender minorities. And increasingly significant themes include new technologies and digitalization, climate change and human rights, and there we offer our competence to the Council's work. In curbing climate change and defending biodiversity, Finland emphasizes the equal participation and rights of women, indigenous peoples and local communities, as well the utilization of their expertise. Equal and meaningful participation in planning and implementing climate actions increase sustainability, effectiveness, efficiency and acceptability of actions. Indigenous peoples live often in sensitive ecosystems heavily affected by climate change. We support indigenous people's rights to be heard and to participate in climate policy and biodiversity policy. The traditional knowledge of indigenous peoples can be drawn to adapt to changes in climate and living environments and consequently to prevent biodiversity loss. But this shall be done only in consultation and cooperation with indigenous communities. Finland recognized the rights to water and sanitation as legally binding human rights. We promote these rights internationally, emphasizing the rights of women. Finland boosts the opportunities of people in developing countries to produce and source safe, healthy and nutritious food. One example of that. Responsible and innovative land administration in Ethiopia is a joint project by Finnish and Ethiopian governments. There are over 50 million parcels in rural Ethiopia. To date, more than 15 million parcels are registered through, by the government and this project. This means that about 5 million households and that is about 20 million people are already covered. The project is helping to curb climate change by addressing land degradation and promoting sustainable land management. When farmers have rights to their land, they can take better care of it and invest more into it. So far, 15% of farmers have reported of increased investments due to land registration. The project may improve accountability, transparency, efficiency, and quality of land transactions as it guides the authorities through the steps of the process. In recent years, the UN Human Rights Council has put more emphasis on the human rights impacts of climate change and environment. And as our State Secretary mentioned, the Council has adopted resolution on the right to a clean, healthy and sustainable environment. And Finland sponsored the resolution, which is not legally binding, but has an added value. It, for instance, gives a possibility to strengthen the linkage between the civil and political rights and economic social rights on the other hand. So we strongly support this kind of approach. We participate in the debate on the international definition of both the non-binding and potentially legally binding instrument concerning the environment and human rights. In addition to the UN, this debate is ongoing also within the Council of Europe. To us, a new treaty or treaties are not an aim or a value in itself. The starting point for potential new environmental human rights should be that it should not fall below the current level of protection. So it has sufficient extent of protection. And it don't limit the scope of the application, so which our rights are protected. And it should not only compile current practice, but improve the level of protection. So this will be a long road, and as we know, the action against international human rights obligations is more visible than earlier, and too many states, including very powerful ones, question universality and legally binding character of human rights. And these states have increased their cooperation in the context, such as the UN human rights bodies. A new treaty with sufficient human rights provisions requires plenty of efforts by human rights friendly states and civil society and their ability to work together. The Human Rights Council has also created an expert mandate on climate change and human rights, and the mandate and capacity to act of the UN Special Rapporteur must be secured, taking account of the increasing weight of environmental issues in the human rights policy. Food security continues to pose a serious global human rights challenge. With global drivers such as climate change, biodiversity loss, and armed conflict, a growing food and energy prices, and they are becoming an even greater challenge, particularly for those living in poverty. International human rights law can serve a critical role in guiding governments to protect health of their populations, particularly among the most vulnerable, and in responding to food insecurity. The UN Secretary General Antonio Guterres has warned that Russia's invasion of Ukraine could very soon cause a global food crisis, and that may last for many years. The UN Human Rights Council had this month the special session on deteriorating human rights situation in Ukraine. The Council adopted a resolution which points out countering the growth of world food insecurity due to the blockade of Ukrainian ports on the Black Sea. Those who are the most vulnerable to food and energy insecurity were one of the greatest concern. All immediate solutions should be sought through negotiations, and all parties should fully respect international human rights law to protect food security. And finally, as a member of the UN Human Rights Council, Finland highlights the participation of civil society and human rights defenders in the work of the Council. We need this cooperation to ensure powerful and legitimate decisions by the Council. Civil society representatives, including human rights defenders, must be able to participate in the Council meetings. With these words, I thank you for your attention. We need you all to promote and defend human rights. Thank you. Okei. Niinpä tietenkin. Mä olisin vienyt kotiin tästä.
Thank you very much, Rauno. My name is Kim Remitz. I'm the executive director of KIOS, and I thank you all very much, all panelists and all you people who have been here today. This has been a very good discussion. Now I have to say I have some mixed emotions now, because I know that we are running late quite much, and you are certainly in a hurry to your next appointments. But if you let me just say a few remarks about the discussion. So yes, this actually reminds me some of our office meetings in KIOS, where we always discuss so much that we run out of schedule. But well, in the first discussion, so it was about the right to clean, healthy and sustainable environment, and we started by stating that half of the global population is vulnerable due to the climate change, and that recognizing the right to clean and healthy environment has been an essential tool for the environmental defenders. However, corporate and state actors are still reluctant due to profits and economic gains. In the second discussion about the indigenous people and the land rights, about the challenges and opportunities, so it is quite clear that the indigenous people are in the forefront of the land right battles. But what seemed to me as one key issue here is that not only the rights, but also the different perspective to nature. So this is something that is essential to conversation to conservation, and it might be also a key issue in the future, that we have to change our mind, our perspective, how we look to the nature. And as Johanna Sumuvuori stated, so 80% of the biodiversity is with the area of indigenous population that represents 5% of the global population. The third discussion about protection and support for the environmental defenders. So as Dorothée Cambou said, so the recognition of the right to clean and healthy environment in the UN General Assembly would be an essential and the instrumental tool for the future for the environmental defenders. And this will be very important. However, the situation in many cases now is very poor for the defenders, and well, state and corporate harassment, fake court cases, violence, killings, and this is especially difficult with the women human rights and environmental defenders, because they are many times the special target. So we need to prevent human rights violations, train people who want to stand for their rights, and it was an important thing also to remember that we need to introduce also a code of conduct for the defenders. Of course, we need also to react. So people who defend their rights, so many times they put their families at risk, and the civic space is shrinking. There is a constant lack of resources and funding, and the activists in Finland face also similar problems, and there is the problem of the extreme right and the political violence also. So I think it is very important that both the human rights and environmental movements need to work together and also defend each other, like we heard also a few examples that has been the case. So with these words, I would like to again thank you all, and for those who want to continue with the discussion, so please keep in contact with Siemenpuu Foundation and also KIOS Foundation, and in the future also we will have a lot to do. Thank you so much.